work with a lot of small and medium-sized healthcare businesses across the US, dental practices, therapists, telehealth platforms, and at some point in almost every engagement, someone asks me whether Google Analytics is HIPAA compliant. And I get why they're asking. They've Googled it, they've read the articles, and the articles say things like disable Google signals, mask your IPs, set your data retention to 2 months, and you're all good. But that answer is wrong. And it's wrong in ways that can put your organization at real legal risk. So let me give you the honest answer. And if you're new here, hi, I'm Dana DiTomaso, and I help marketers just like you solve real analytics problems that you encounter every day. If that sounds like something you need in your life, please make sure to subscribe. A quick note before we go further. HIPAA is a United States law, so if you're not in the US, this does not apply to you. And nothing in this video is legal advice. I am definitely not a lawyer. Your compliance team and counsel should get the final word in your specific setup. All I'm here to do is give you the clearest possible picture of the landscape so that you can have an educated conversation. So why does everyone say just turn off Google signals? Because then it sounds like a configuration fix, and configuration fixes are both easy and satisfying. You go into the GA4 admin panel, you flip a toggle, you feel like you've handled the thing, all done. But unfortunately, HIPAA compliance for analytics has almost nothing to do with configuration. It's about whether or not you have a business associate agreement, a BAA, with the vendor that's going to receive the data. Now, here's what a BAA actually does. When a HIPAA-covered entity, your clinic, your hospital, your telehealth platform, shares protected health information that's called PHI with a third party, that third party has to be contractually bound to handle the data under HIPAA's rules. The BAA is that contract. Without a BAA, there's no legal pathway for that data to leave your walls. And Google will not sign a BAA for Google Analytics. Their own help page says Google makes no representations that Google Analytics satisfies HIPAA requirements. It's not a configuration problem, that is the deliberate vendor position. Now, Google does sign BAAs for certain workspace services and specific Google Cloud products. BigQuery, Cloud Storage, Cloud Healthcare API, those are infrastructure products that healthcare organizations use to handle real PHI in controlled environments. GA4, Google Tag Manager, Google Ads, not on that list, not ever. So when you're evaluating any analytics tool, the first question isn't what does it collect, but will they sign a BAA? Because if the answer is no, no amount of configuration will get you to compliance. Now let's talk about what actually counts as PHI in your analytics setup because it's broader than a lot of people would expect. PHI isn't just medical records. In an analytics context, it's any combination of identifiers and health contexts that can then connect a person to a clinical purpose. The classic example, an IP address paired with a URL like appointment/oncology. The IP isn't PHI on its own, the URL isn't PHI on its own, but together on the right page, they create a record that says this person is seeking care for this specific condition, and that is PHI. In December 2022, the HHS Office for Civil Rights put healthcare organizations on notice that running analytics tools on pages with patient information was a HIPAA issue. They updated the guidance in March 2024. Then the American Hospital Association sued over it. And in June 2024, a federal court in Texas vacated part of that guidance, specifically the part that said connecting an IP address to an unauthenticated public web page about a health condition automatically triggered HIPAA. So a public marketing page about your oncology services viewed by someone who isn't signed in is no longer automatically a HIPAA problem under that vacated guidance. But the ruling did not change. Authenticated pages still do count. Patient portals, logged in scheduling, anything where someone is identified, that is still very much in scope. And class action plaintiffs don't actually need that OCR bulletin to file. Since 2023, U.S. healthcare providers have paid out more than $100 million in pixel tracking settlements. Almost none of them were OCR penalties. They were class action lawsuits filed in state privacy laws, consumer protection statutes, and common law torts. State law is its own layer. California's CPRA, Washington's My Health, My Data Act, New York's SHIELD Act, these can apply even when the federal analysis may not. One more thing I want to flag here because I keep seeing it overlooked is that heat map and session replay tools such as Microsoft Clarity, Hotjar, these are often a bigger PHI risk than GA4 because they can record what people actually type. If someone starts filling out an appointment request form and your session replay tool is running, you might be capturing the content of that form in real time. That's not a gray area. That's a problem. So given all of that, what are your actual options in 2026? Here's what I recommend looking at. The first option is GA4 and only truly public marketing pages only. After that June 2024 ruling, this path is more defensible than it used to be. Homepage, about pages, blog content, public service descriptions, these are lower risk for GA4. You still have state privacy law exposure and you still need a consent strategy, but this is workable for a lot of smaller healthcare organizations. Option 2 is server-side tagging with PHI scrubbing. The idea here is you intercept the data before it hits GA4, filter out URL parameters and event payloads that could carry PHI, and only pass clean data through. STAPE is a managed option for server-side GTM. FreshPaint is a data governance layer designed specifically to scrub PHI before any downstream tool receives it. The honest caveat for that, though, is that this doesn't solve the BAA problem. The data will still end up in Google's infrastructure, just pre-filtered. It does reduce your PHI exposure, but it's not the same thing as having assigned BAA. Option 3 is HIPAA-eligible analytics tools for PHI adjacent pages. This is where I'd point you for anything beyond the public marketing layer. PostHog, for example, will sign a BAA in their platform packages. Pickwick Pro offers a BAA in their enterprise tier, and they have a self-hosted option. Matomo is self-hosted only if you need HIPAA compliance. Matomo Cloud will not sign a BAA. Plausible and Fathom both have strong privacy postures, but make sure to confirm with them their BAA terms before you rely on them for compliance. And then option 4 is split tracking by page type, and no third-party tracking in the most sensitive pages. This is actually my recommended approach for most healthcare clients. GA4 marketing pages, a HIPAA-eligible tool on PHI adjacent pages, and then for the appointment flow and patient portal interior, no marketing analytics at all. Use operational server logs only, analytics decisions or strategy, not data accounting, so you don't need to track everything. Now here's the practical thing I help clients set up, and that's a page classification system. Every page in your site goes into one of 4 buckets. The first bucket is marketing. Homepage, about pages, services overview, blog, public condition information. GA4 is usually okay here with your state law consent layer in place. The second bucket are transactional but not PHI. These are contact forms without health information, location finders, and general inquiries. Evaluate those on a case-by-case basis. The third bucket are PHI adjacent forms. For example, appointment request forms, condition-specific landing pages with intake fields, anything that combines patient identity with clinical purpose. Don't use GA4 here. And then the fourth bucket are patient portal and authenticated pages, logged in everything. No GA4, no marketing pixels. Server operational logging only. Once you have that classification, you can enforce it in GTM. You can create trigger exceptions based on page path patterns, you can use excluded URL parameters, or set up a page type variable as a lookup table and use it as a condition on every tag. If you use machine enforced rules, then you're not relying on someone remembering to turn off a tag before you launch something. And then make sure to document it. A page classification matrix, a tools list with what data each tool receives, BAA status for each tool with signed agreements on file, your retention settings, your consent banner integration, and your GTM enforcement rules. Review it quarterly, run QA spot checks regularly. When your compliance team asks, and they will ask, you hand them that document instead of scrambling to explain what's happening on your own website. So, here's 3 concrete steps you can take this week. First thing, you're going to classify every page of your site into these 4 buckets. The second thing you're going to do is pull the BAA status for every tool that touches your healthcare pages, not just GA4, everything. Third, you're going to bring that classification matrix and your BAA list to your compliance team before they come to you with questions. And that's it, that's the foundation. If you're working through this and you hit questions that I didn't answer here, make sure to drop them in the comments. This is one of those areas where I think the healthcare marketing community deserves better resources than what you're being provided right now and what's out there at the moment. And so I want to make sure that this channel can be part of fixing that. If this was useful for you, please share it with someone in healthcare marketing who's still relying on the just turn off Google Signals answer. And if you're not subscribed yet, well, now's a great time to do so. I'll see you in the next one.